Today on Bench Briefs, we're looking at a landmark Supreme Court of Canada decision that explores the balance between Indigenous rights and provincial authority over natural resources. The case is Quebec Attorney General v. Pekuakamiulnuatsh Takuhikan, decided in 2024, and it delves into the complex relationship between a First Nation community's traditional rights and the laws of the province they live in. At the heart of this case is the Pekuakamiulnuatsh Takuhikan, a First Nation community based in Quebec. They have long-standing connections to their ancestral lands, which include rights to hunt, fish, and manage natural resources, activities that are central to their culture, economy, and way of life. These rights are protected under Canada's Constitution, recognizing the unique status and history of Indigenous peoples. However, the waters get murky when provincial laws come into play. Quebec's government enforces regulations over natural resources, including hunting and fishing rules, meant to manage and conserve these resources for all residents. The Pekuakamiulnuatsh Takuhikan challenged these regulations, arguing that they infringe on their constitutionally protected Aboriginal rights within their traditional territory. The dispute began when provincial authorities enforced these regulations against members of the Pekuakamiulnuatsh Takuhikan community, limiting their ability to hunt, fish, and manage resources as they traditionally have. The community contended that these provincial laws should not apply to their activities on their ancestral lands because doing so violates their Aboriginal rights, which are constitutionally protected under Section 35 of the Constitution Act. 1982. The legal questions the Supreme Court had to address were threefold. First, do the Pekuakamiulnuatsh Takuhikan hold constitutionally protected Aboriginal rights to hunt, fish, and manage natural resources in their traditional territory? This question is fundamental because it recognizes whether their practices are legally safeguarded against provincial interference. Second, the court examined the extent to which provincial laws regulating natural resources apply to the Pekuakamiulnuatsh Takuhikan's activities on their lands. In other words, can Quebec impose its regulations on this First Nation community's traditional practices, or do those rights trump provincial legislation? Third, the court had to consider whether such infringement could be justified under Canadian constitutional law. This involves a complex test that looks at whether the government's actions are reasonable and necessary, respecting both Indigenous rights and broader public interests. This case is significant for several reasons. It highlights the ongoing challenge of reconciling Indigenous rights with provincial authority, especially in resource-rich areas where different interests often collide. The Supreme Court's decision clarifies how far Aboriginal rights extend when it comes to managing traditional lands and resources, and under what conditions provincial laws can apply. Moreover, the ruling sends a message about the importance of respecting Indigenous self-governance and stewardship of their territories. It acknowledges that Indigenous communities are not just stakeholders, but rights holders with constitutionally protected interests that must be carefully balanced against provincial regulations. In the broader picture, this case contributes to the evolving landscape of Indigenous law in Canada. It reinforces the principle that Aboriginal rights are not absolute, but must be accommodated in a way that respects both Indigenous traditions and the rule of law. It also underscores the need for governments to engage meaningfully with Indigenous communities when developing policies that affect their lands and resources. For the Pekuakamiulnuatsh Takuhikan, this decision affirms their connection to their traditional territory and their role in managing its resources. For Quebec and other provinces, it offers guidance on how to regulate natural resources without unjustifiably infringing on Aboriginal rights. Thank you for listening to this episode of Bench Briefs. Join us next time as we continue to explore important legal decisions shaping Canada's justice landscape. Until then, take care.